Yeah, so I will not be talking as much about the EU AI Act specifically as many of the other talks that we'll have this weekend. Rather, I want to sort of zoom out about how this fits in well or in challenging ways in this broader architecture of AI governance. And so it's going to be a sort of view from 40,000 feet at what else is happening in this space and how might that be relevant for specific instruments like the EU AI Act and how should we think about this. And this is based on a forthcoming book in October that I have been writing in this space, which you should all buy, or you should at least take the open access PDFs for it. And the brief overview here is sort of like thinking about how we shape a global governance architecture for AI, well, some versions of AI or advanced AI, and thinking about what's the status of all that going so far, what is the tool set we have available, and what are some of the goals or considerata or criteria here. In academia, a governance architecture is defined as this very broadly. It includes public and private institutions on a certain area in world politics. It includes organizations, regimes, principles, norms, regulations, decision-making procedures, basically the whole basket. And if you think about sort of AI governance to date, and this is an extremely compressed history, but sort of you can think about these different, almost parallel tracks that are occurring, where from around 2015 onwards, you start seeing a bunch of initiatives that focus on conventional AI, or like predictive AI, narrow AI. These are systems that have impacts across many different domains, but the systems themselves are quite narrow. And so we see the rise of AI ethics principles, the OECD principles, and a bunch of soft law mechanisms, but also, of course, the binding principles under the EU AI Act, specifically the high-risk provisions, and the Council of Europe's Framework Convention. In parallel, and actually starting a bit earlier already, although it didn't really kick off until 2014, there's a track focused on military AI governance. So the governance of the international security impacts from AI systems in military or security roles. And this takes place in a bunch of more, so primarily in the UN Convention on Conventional Weapons, but in parallel also in unilateral initiatives such as the Partnership for Defense, the GC REAIM, and only more recently have we seen a bunch more sort of larger sort of activity at the UNGA because there's been such gridlock at the group of governmental experts. And finally, and perhaps most relevantly to the discussions in this weekend, there's been since 2022, starting prior a little bit to the deployment of ChatGPT, but especially taking off in 2023, a sort of track that focuses on societal scale risks, however defined, from either sort of paradigm shifting, so sort of like AI systems, AlphaFold, things that can do things that no human can actually do, or general purpose AI systems that can work adequately well across many different domains. And these risks and often are sort of considered to derive from misuse, misalignment, and loss of control. And so we can see this already sort of taking place, obviously, in the sort of pivot of the AI Act negotiations in the final track. And then most famously, of course, in the AI Safety Summit process, but there's also been, a new wave of industry initiatives as well as UN processes. And so, but with all that activity, there's still a bunch of challenges, and amongst many, so many of these regimes are non-binding, and they have fragmented, sort of geographically fragmented membership. And there's, especially in the last year, obviously, we've had some contestation over either the fact of whether there should be these initiatives, with the US sort of critiquing many of the UN initiatives, or the direction of them, and if they should be focused more on risks or on sort of like, opportunities. And so with that, I want to sort of look at, okay, what is the toolbox that we have available, or that states have available, or different actors have available, either to shape and create this architecture or to contest it. And so, and in contesting is also very important because there are many different epistemic communities that are active in this space. And so, sort of running through this very briefly, you can think about unilateral state actions. This is not often sort of maybe discussed in the context of governance, but it's sort of like, obviously, states can take new activities to try and control the either configuration or the diffusion from AI at the source, either through expert controls, hardware backdoors, or different sort of policies very upstream. in a more coercive sense, there are activities that states can and have taken in various domains of international law, and where they rely mostly on signaling pressure or threats. We've seen it sometimes in the cybersecurity, in the cyber war domain, at least in the early years. And so you can sort of think about proposals such as the MAME proposal recently to sort of maintain a degree of deterrence or stability amongst states by relying on threatened military actions or threatened sabotage of major training runs. Or you can sort of go more sort of easily like diplomatic pressure and coercion, or you can sort of put up economic pressure and coercion. These are, of course, maybe from a broad governance perspective, not very ideal because they sour the conditions and the goodwill for many other governance instruments to work. There's also, of course, and we've heard a lot about this already, unilateral regulatory policies, either with sort of extraterritorial effects or upstream effects. And yeah, I think I've had several mentions of the EU-Brussels effect. Interestingly, this can work beneficially, but there can be interesting effects on the architecture if you get a sort of regime conflict. And we've seen this in environmental law and trade law, where trade regime and the WTO trade regime often overrules environmental regimes. And there's been at least suggestions that similar effects could come to be at play in the global architecture, where it suggested that sort of product safety focused frameworks like the AI Act might at least not mesh well, or at least experience sort of norm conflicts with the framework convention that's been developed by the Council of Europe. Separately, of course, states could regulate intermediaries, and there's some good work by Bomir and others to look at okay, what are the kind of artifacts that we're talking about? Are they sort of like very decentralized? Are they very centralized? Are they very physical? Are they very sort of digital in this broad supply chain? And that really changes the feasibility of doing extraterritorial regulation and the efficacy. There's also sort of states can just apply existing treaties to AI by declaring them that they sort of consider them so. There is a challenge. I mean, you can do that either through sort of explanatory memoranda of how they interpret the treaty, or in sort of more extreme cases, they can sort of withdraw from a treaty and call for like the negotiation of new treaties, or embed reservations. The challenge here is that, especially in multilateral regimes, if not all state parties agree to this, you end up fracturing the regime, and that's not good for the treaty or the governance. A separate tool, the next tool, is the rise of non-binding global soft law. This has had a long history in AI. There is, of course, so there's an interesting thing about sort of self-regulatory or co-regulatory codes of conduct. There is some challenge that often they are non-enforceable, and there are a bunch of domains where they've had a mixed track record, either because they rely on, they're too narrowly scoped, or they rely on NGO enforcement, which is not always easy or effective, or it requires resources that the NGOs don't have. Or they just didn't get broad sign-in. Luckily, at least some of these initial sort of failure modes, the Code of Practices seem to have sort of avoided. Of course, an interesting thing about codes of practice, and this is as we've seen with the AI Act Code of Practice, is that you can indirectly back them up with binding regulation by making them the proof or standard to show presumption. And in some cases, there's a discussion that you could eventually also sort of make them, if there are later further binding regimes or laws, you can make them sort of by reference a binding code. This is sort of what's happened in some sense in WTO agreements, where the WTO has a presumption that if you don't have other standards, you should apply ISO standards. And so even though ISO standards aren't binding, they can become binding because under the WTO, states might have to refer to them. Another tool is bilateral agreements, whether you are sort of confidence-building measures between states, or sort of narrowly scoped pre-deployment agreements, or in the context of more like military uses, having deconfliction hotlines around the use of these systems. We can, as international lawyers like to say, apply public international law norms. They are old. That does not mean that they're outdated. Treaty law has a whole bunch of applicable state obligations. You can think about directly applicable rules to some part of the AI supply chain. You can think about sort of other rules that are, they might be applicable, but there needs to be some doctrinal clarification. So there's some discussion over, well, if you've got AI advisors, do they like, under trade law, are they a good or a service? In which case, which regime do they fall under? If you have autonomous ships, is that regulated in like the right to hot pursuit under the UN Convention on the Law of the Sea? self-driving cars don't neatly fit into the road traffic conventions, which require a human sort of operating the vehicle. But there is a lot of activity at the Global Forum for Road Traffic to resolve this. However, a lot of these existing treaties are more neatly fitted either to sort of upstream levels, so like some like data processing, but not often to like sort of compute governance. And a lot of them are and a lot of the other ones are very focused on use cases, not on general purpose systems neatly. You can think about customary international law, which is sort of whatever all states do and do because they seem to think it's the law. And this is broad and it is abstract, and so you can apply this, but it again needs interpretation. And there's I won't go through this all, but there is a whole bunch of principles in our international law that would apply to this and that you could feasibly apply. And of course, this has been the generator of a huge amount of literature in the last 10 years. The fact that people don't easily agree does not mean that you couldn't see development of this as states start to reach settled positions on this. Then there's and so related to that, you can think about, okay, well, what helps in the development of legal norms? One avenue is sort of, you can look at what international arbitral bodies or international courts develop in case law. This can take into consideration evolving scientific consensus, and it can just clarify how these norms apply. And we've seen this even in strictly non-binding advisory opinions in the climate change case, where the ICJ and the Inter-American Court on Human Rights have developed basically what are human rights obligations, what are and the Tribunal on the Law of the Sea as well. What does the Law of the Sea say about climate change? But of course, a lot of this can be reactive and slow, and also there is this mechanism by which if you try to apply principles or rules that were derived for a very different regime or a very different issue to something very different, sometimes it doesn't pass the so-called laugh test, where it's sort of like people have attempted to apply the Hague conventions on that ban bombardment from balloons, and then in the 80s they tried to use this to say you can't have bombardment stations in outer space in geosynchronous orbit, and that's maybe a bridge too far. Another avenue is you could develop new customary law if states just develop settled expectations and behavior. We've seen this in hostile cyber operations. This may require time and state practice, and it often can be shaped by the bottom-up operational practices. So just what do states mean when they say we have integrated meaningful human control, or we have integrated responsible scaling policies, and that is tricky because by the time you finally reach agreement on a top-down norm, then states are already sort of like jumping ahead. But there is some interesting possibilities to accelerate this. I think there's recently been work in the cyberspace where you can issue a handbook which states can use to have it like a checklist about what are all of the topics that they should develop their position on, and you can sort of say, as a checklist, maybe you should think about what international law says about agents. And in doing that, you allow a far wider range of states to consider these issues and put them on the agenda. You may not be able to sort of have much control about what they sort of say as their position, but you could, if you sequence correctly sort of which states take the lead on that, you might sort of get a bandwagoning effect on a bunch of that. And finally, there's of course a lot of discussion of international institutions. I'll go through this a little bit quickly. I think this is tricky because while there's a whole bunch of proposals, it's unclear how viable those are currently, and it's also a quite slow solution often. And it's not clear if you should sort of present them as singular, comprehensive frameworks or more than modular elements. And then there's a whole set of like future solutions. You can think about new types of institutions. I mean, this has been very popular in the US and the domestic level. You can think about what would it look like to have private regulatory markets. Or you can think about what are some of the affordances that these technologies create for states around the coordination frontier. There's a whole body of work on how AI can be used to facilitate diplomacy or in monitoring treaty violations and compliance. There's been recent work on sort of flexible hardware-enabled guarantees. So how can you have computing systems that allow you to verify whether the user is complying by certain use agreements? Or in some recent work that we've been undertaking, and this is a working paper, we're looking at how you get AI systems themselves to interpret and abide by treaties. And so I think finishing off, why is this useful to have this broader sense? Well, many of these other governance initiatives aren't really operating in a vacuum with the Code of Practice or the EU AI Act. we need to understand how they relate to each other. We need to think about how they can be parallel, how they can be complements, and how they can be competitors. And okay, I'll jump to the end now. I think you should. The rest of this is all discussed in my book, and I'm very happy to talk about this. I will unfortunately need to leave shortly after this, in which case, please send me an email, and I will very happily chat about this. Cheers.